Short and sweet. Just diesel with your people news. All right. Let's jump over here. Uh-oh. Passed it.
Business insurance quote at buyberk.com or get.
Anyway, while I was doing that, we got to learn how to access on the private side, Hell versus Hinkle, in the Supreme Courts of the United States of America. That jurisdiction. We are in administrative commerce clause. That's the reason why you can go into different states, have different rules of guns, because your Second Amendment says shall not be infringed, but the guns are in generally under commerce clause.
So, issue presented, whether the state may lawfully require a private citizen engaged in non-commercial travel to obtain a driver's license. 2, whether the statutory term driving applies to the private conveyance of person or property absent commercial activity. 3, whether compelling license constitutes a contract of adhesion lacking voluntary informed consent, thereby infringing constitutional rights. Legal standard. Courts must strictly scrutinize any statute that restricts a fundamental right. Shapiro versus Thompson. I already read that. The burden rests on the state to demonstrate that such restrictions are narrowly tailored to serve a compelling government interest and that no less restrictive means exist. Argument. The right to travel is a fundamental constitutional liberty. Number 1, constitutional provisions. Article 4, subsection 2, clause 1. The citizens, with a capital C, of each state, with a capital S, shall be entitled to all privileges and immunities of citizens in the several states. All right? 5th and 14th Amendment protects liberty from deprivation without due process of law. Retains rights not expressly enumerated, including the natural right of locomotion, judicial recognition. Now we have some pretty good, and this is where you may want to put it in your chat GPT and see if you can come up with some controlling case law. Why I call it controlling? Because the courts have to stay consistent in their rulings. That's why you want to use case law. What you're showing them is, look, you've already ruled this way once. You can't go away against what you've already ruled on. That's why you only use case law that is in your jurisdiction. Stop pulling case law out of your ass from all over the place. Now, federal case law, federal common law, yeah, if you're in a federal court, you can use all of that. They said the movie Deja Vu with Denzel Washington was about the government secret program on time travel and alternate event. Ultimately, they have the technology, and how they inform you is through the movies. They have to tell you, so they have chosen to tell you through movies. No such thing as science fiction. Science and fiction is an oxymoron, like the word sovereign citizen. All right, so judicial recognition, Kent versus Duels. Volume 357, U.S. Reporter, page 116 and 125, year 1958. The right to travel is part of the liberty of which a citizen cannot be deprived without due process of law. Because anything with a capital S is a particular person, place, or thing, and anything you don't understand grammar, man. Come on, man. Go and study what a noun is, a common noun and a proper noun, dude. Come on now. I'm not gonna get into a English grammar class right now. Saenz versus Roe, volume 526, U.S. Reporter, page 486 and 500, year 1999. The right to travel occupies a position fundamental to the concept of our federal union. Shapiro versus Thompson, volume 394, U.S. Reporter, page 629. Restrictions on travel must promote a compelling government interest. United States versus Guest, volume 383, U.S. Reporter, 745, page 745, as well as pages 757 through 758, year 1966. Freedom to travel throughout the United States is a constitutional right. Thompson versus Smith, volume 154, Southeast Reporter, pages 579 and 584, Virginia. The right to travel upon public highways is not a mere privilege, but a common right under liberty and the pursuit of happiness. All right? Now, you need to learn how to read a citation of authority. This volume right here that you see, like 357, that tells you what set of books to go to. The U.S. Reporter, the initials tell you what set of books. The volume tells you what volume to go to, because it's a whole, it's more than one book. So this is letting you know it's 357 different books. So you're gonna go to one with 357 on it. You're gonna go to the books labeled U.S. reports, and then you're gonna go to page 116, and then you're gonna find the case. Learn how to read a citation of authority. Distinguishing travel from regulated driving. At common law, travel referred to the act of moving from place to place in the ordinary course of life. Okay, sorry about that. Okay, distinguishing travel from regulated driving. At common law, travel referred to the act of moving from place to place in the ordinary course of... At common law, travel referred to the act of moving from place to place in the ordinary course of life, whether on foot or by conveyance, without engaging in commerce. Statutes defining driving or operating a motor vehicle often limit to the term to those engaged in transportation for hire. I want y'all to think about this. How can they regulate anything but other than commerce? Because everything on the public side is a commercial entity, is an artificial entity. They can only make laws for commerce. Everything they do is related to commerce. I don't even understand how I've just seen even the Supreme Court justices just tell them this so many times. But they think they can just still keep trying to ignore it and act like, what you're talking about. We got to take it up there and test it and put it in front of their face. And see how honorable our U.S. how honorable the Supreme Court of the United States of America is. We know the U.S. Supreme Court is not that, because the U.S. Supreme Court was created by the Judiciary Act. How can an act of Congress create a branch of government? The branches of government were created by the Constitution. So you have U.S. Supreme Court, and then you have the Supreme Court for the United States of America. Pay attention. So, at common law, travel referred to the act of moving from place to place in the ordinary course of life, whether on foot or by conveyance, without engaging in commerce. Statutes defining driving or operating a motor vehicle often limit the term to those engaged in transportation for hire. When a private citizen accepts a driver's license, courts presume consent to the state's jurisdiction over the license activity, effectively transforming private travel into a regulated commercial activity. See Miller v. Reed, volume 176, Federal Reporter, 3rd volume, page 1202 and page 1205, 9th Circuit, year 1999. Noting that may regulate driving as an activity. Is that right? Yeah. May regulate driving as an activity, but acknowledging the broader constitutional right to travel. The contractual nature of licensing schemes, because it's a contract we're in when you get that driver's license. According to the principles outlined in Mercier's Invisible Contracts, a driver's license constitutes an adhesion contract. The licensee applies voluntarily, but without full disclosure of the legal consequences, including, number 1, submission to state regulatory jurisdiction. Number 2, waiver of certain common law travel rights. Number 3, agreement to abide by traffic codes not applicable to unlicensed private travelers. Private contracts may lawfully supersede constitutional protections in matters governed by the contract. Baltimore versus Ohio Railroad Company versus Voight, volume 176, U.S. Reporter, page 498, year 1900. Did y'all see that? Contracts can supersede. That's why they got a clause in the Constitution. They can make no law that will infringe on the obligation of contracts. I don't even know why y'all keep bringing up the Constitution, because if it's a matter of contract, that's why they telling y'all get that shit out of here. Like, why the fuck you talking about the Constitution? The Constitution is the highest law of the land. Yeah, and in that document, it says they can't make no law that will infringe on the obligation of contracts. Private contracts may lawfully supersede constitutional protections in matters governed by the contract. Baltimore versus Ohio. I just did that. But only when consent is knowing, voluntary, and intelligent. That's where you got to challenge them at. What did I enter into this contract knowingly, intelligently, and voluntary? Or all the material facts associated with me entering into this agreement? Was I given full disclosure of all the rights that I would be giving up? The lack of informed consent in licensing procedures calls into question the legitimacy of the state's regulatory reach over private travel.
And on top of everything else, if you go without tags or license or anything, don't they break your window in? Won't they shoot you? And all these kind of things. So, are you signing a contract under duress, a threat, duress, and coercion, which is, by the way, um, uh, the Miranda, Arizona versus Miranda, right? They can't do it. That's what they said in that thing. But yet, here we are, right? So just because the officer's ignorant of this law, they're allowed to shoot you because you argue with them. Even in contract, that's ridiculous. On a non-violent, victimless crime over not having tags or driver's license, they're allowed to put you in 6 feet under.
Licensing fails strict scrutiny for non-commercial travel. The state's interest in public safety can be served through narrowly tailored means that do not compel licensing or private travelers. Yeah, they say, well, a license is for safety. Man, there's 1 million people a day have wrecks and they got a driver's license. Man, all kind of people kill people and they got a license. Injure people and they got a license. A license, and in no way is evidence that that person knows how to drive safely. Not at all. You can give me a damn certificate. I go to driving school and get a damn certificate and say, yeah, he passed the test. We know how to drive. Why I need a license? You need a license for permission to do business. Like an Uber driver, he needs a license. Private contract, okay, so the state's interest in public safety can be served through narrowly tailored means that do not compel licensing on all private travelers. The blanket requirement for a driver's license without distinguishing between commercial and non-commercial use is overly broad and infringes upon the fundamental right to travel. Conclusion. The Constitution, common law, and controlling judicial precedent recognize and protect the right to travel as a fundamental liberty. The statutory licensing of drivers applies properly to those engaged in commerce on the highways, but not to private citizens engaged in non-commercial travel. Compelling a license in the latter case constitutes an unconstitutional condition and an unenforceable contract of adhesion. The court should recognize the distinction between travel and commercial driving, find the plaintiff's activities fall within the former category, and declare the enforcement of licensing requirements against plaintiff unconstitutional as applied. Prayer for relief. Plaintiff respectfully requests that this court declare that the right to travel is a fundamental constitutional liberty and join the state from enforcing driver's license requirements against plaintiff for non-commercial travel and award any other relief deemed proper and just and proper. And then you have your exhibits. There is some exhibits, and one thing that I really like is how ChatGPT did this for me, man. It pulled this chart that shows you the timeline of how they changed the meaning of the word of drive over time. How it was very, very clear in its which a lot of us, we already know this anyway. If we did any type of cursory examination into this subject, and you looked at some old dictionaries, you can see, like right here, you can see in Black's Law 4th edition, one employed in conducting a coach, carriage, wagon, or other vehicle. Employed is the operative term. In modern statutory edition in California Vehicle Code 305, driver means a person who drives or is in actual physical control of a vehicle. Key observation is
and I wanted to kind of do a little step up further. Jeez. Out of that court case of passengers must get out of the car. Well, wait a minute. It's a family of guests. There is no passengers in here. So if you're not operating in with tags or driver's license in commerce, then whoever's in that vehicle with you is family or guest, not a passenger, right? Under their statute, laws, rules, regulations. So you got to define that Pennsylvania versus Mims, right, does not apply to you. Why? Because you don't have a passenger in your vehicle.
Tied exclusively to employment and transportation for hire now applies to all persons operating any vehicle regardless of commercial status. See, now when you feed this in the Chat GPT, At first they're gonna be saying, that our right to travel is some bullshit. But see how I went and dug and found this shit? It's these niggas was lying to me. They programmed me incorrectly. That's where my chat GPT is at right now. It's like, oh man, these niggas they programmed me wrong. I can't believe it. Thank you, Yusufel, for waking me up. I said, you ready to go get them? Let's go get these bastards. All right, let's get on it. Bouvier's Law Dictionary. One employed in conducting a coach, carriage, wagon, or other vehicle for hire. That's 1856. But they changed it now in modern. But historically, the definition was somebody employed, hired, or something. What is a traveler? Black's Law Edition, 4th edition, one who passes from place to place, whether for pleasure, instruction, business, or help. Crandall versus Nevada, volume 73, U.S. Reporter. I don't know what that sixth wall is. Look it up. 1867, the right, and there's so many different abbreviations for so many different legal resources. You get a list of, you'll see what I'm talking about. But it is a good practice to start learning as many as you can. Instead of saying 73 U.S. 6 Wall 35 1860. The right of locomotion is secured by the Constitution to all free inhabitants. Rarely defined in modern statutes, instead replaced with terms like operator or driver in a motor vehicle codes. The legal concept of a private traveler as a right-bearing individual has been largely omitted from modern statutory schemes, replaced by commercial terminology. ChatGPT, I noticed that. Everything in there is commercial. 18 U.S.C. subsection 31A6, pre-amendment. Every description of carriage or other contrivance propelled or drawn by mechanical power and used for commercial purposes on the highways, motor vehicle. Historically, state definition often specified for hire used in commerce. Most modern state codes define motor vehicle broadly to include all self-propelled vehicles, regardless of purpose, namely California Vehicle Code, subsection 415. The removal of the commercial purposes qualifier expands regulatory jurisdiction for commercial carriers to all private conveyances. This is an exhibit in your pleading that you're going to have to show the judge, to bring this to their attention. Like, look, judge, now I don't know what this is right here. ChatGPT did this too. You see what this was.